What happens when war regulations restrict your business and you walk away from your lease? Stay tuned. Welcome to 99 Rights Online, your crash course in rights, rulings, and real-world justice. We simplify the law without dumbing it down because informed citizens make powerful communities. In Lloyd versus Murphy, the California Supreme Court had to decide whether federal restrictions on selling new cars excused a tenant from paying rent, or whether the lease still had value. On August 4, 1941, the plaintiff, Caroline A. Lloyd, leased the Beverly Hills premises to the defendant, a one William J. Murphy, for 5 years, beginning September 15, 1941. The purpose of the lease: the sale and servicing of new automobiles, with limited exceptions for used cars and petroleum products. The lease prohibited subleasing or assigning without the plaintiff's written consent. Fast forward to 1942, wartime rules limit who can buy new cars. Sales drop. The federal government ordered the discontinuation of the sale of new automobiles due to wartime restrictions. On March 10, 1942, plaintiffs orally waived restrictions on use and subleasing and offered to reduce rent if business became unprofitable. The tenant Murphy vacated the premises on March 15, 1942, and repudiated the lease, saying the lease's purpose is frustrated. So the issue the court had to answer was, did federal restrictions on new car sales frustrate the purpose of the lease, excusing defendant's performance? And did plaintiff's waiver of restrictions and offer to reduce rent affect defendant's obligations? Rule: Doctrine of frustration only applies when an unanticipated event destroys the contract's purpose, making performance vitally different. Mere hardship or reduced profit isn't enough. The burden is on the promisor to prove: 1. The event was unforeseeable, and 2. The value of the contract was totally or nearly totally destroyed. Also, the government regulations that make performance less profitable or difficult do not excuse obligations unless they entirely prohibit the contracted purpose. Here, federal restrictions did not entirely prohibit business. They only restricted sales, making business less profitable. They also waived restrictions, allowing the defendant to use the premises for any legitimate purpose or sublease. This was how they preserved lease value. And the risk of war and restrictions was foreseeable when the lease was executed. The absence of a provision addressing the risk meant the defendant assumed the risk. Also, the tenant still sold cars elsewhere, so the purpose wasn't wiped out. So, the lease remained valuable. Repudiation was unjustified. The California Supreme Court affirmed the trial court judgment. The doctrine of frustration did not apply. The lease purpose was not totally destroyed. Tenant owes unpaid rent, minus what the landlord re-rented, with interest. So, why does this case still matter today? For law students, it is a classic case defining the limits of frustration of purpose in contract law. For businesses, it shows that foreseeable risks must be accounted for in contracts. And for citizens, it demonstrates that reduced profits don't excuse contractual duties unless the purpose is completely destroyed. The bottom line: courts apply frustration narrowly. Foreseeability and total destruction matter. Thanks for watching. This was 99 Rights Online, where law gets loud, clear, and viral. Subscribe for justice that hits different. If this breakdown made the law feel a little less intimidating and a lot more powerful, don't scroll away just yet. Like, subscribe, and share to keep your rights sharp and your feed spicy. Because justice isn't just for lawyers, it's for everyone.